Hello and welcome to another edition of Lunch and Learn with Legacy Washington. Legacy is a history program within the Office of Secretary of State Kim Wyman, along with our colleagues in the State Archives and State Library. And I'm Bob Young, a historian with Legacy, and I'm very pleased to introduce our guest today, Gerry Alexander, the longest serving Chief Justice in the history of the Washington Supreme Court. Welcome and thanks, Justice Alexander. Great to see you.
Nice to see you, Bob. Great to be here with you.
We will come back to Justice Alexander's biography in more detail, but quickly, he grew up in Olympia. He went to the University of Washington. He served in the U.S. Army as an infantry lieutenant. He came back to Olympia to open a law practice, and then he was first appointed a Superior Court judge in 1973 and was first elected to the state Supreme Court in 1994. That was a year after he outran NFL Hall of Famer Lynn Swann in the New York City Marathon. We'll get to that later. So, Justice Alexander, you heard more than 2,300 cases in the Supreme Court. You wrote more than 400 opinions, but you are particularly proud also of your work in rewriting a couple bits of Washington history. So with this being a history program, let's dive into those. And the first was the case of Mr. Takuji Yamashita, a Japanese immigrant who was in the second class of the University of Washington's fledgling law school in 1902, one of 10 graduating students. And although Mr. Yamashita graduated and was considered quite fit intellectually and morally to be an attorney, he couldn't become one because of anti-Asian sentiment and laws of the time. Mr. Yamashita then went into business and was successful, but when World War II came, like 110,000 other Japanese Americans on the West Coast, he was incarcerated in a so-called internment camp, lost his businesses. After that, he became like a caretaker for a widow in West Seattle, and then went back to Japan and passed away in 1959. So I wanted to ask you, Justice Alexander, how did you get involved in the idea of bringing some justice to Mr. Yamashita's legacy?
Well, prior to 2001, really, I had never heard of Takuji Yamashita, even though I am a graduate of the University of Washington School of Law. I knew nothing about him, and my knowledge about him came about because I was approached by the then dean of the University of Washington Law School, Ron Yorth, who was really a fine man and a great, in my opinion, one of the great deans of the UW Law School. He indicated that the UW Law School was about ready to celebrate its 100th anniversary as a law school, and that the law school felt that an appropriate way to celebrate that was to recognize the fact that Mr. Yamashita, a graduate of the second law school class, as you mentioned, from the University of Washington in the early 1900s, had been denied admission to the bar of the state of Washington. And they would like to see if that could be rectified, even though he was deceased, obviously. And asked me, would, in my opinion, the court be willing to consider a petition to admit him posthumously to the bar. And I told him, after I heard the story about Mr. Yamashita and how he had suffered like the biblical Job, I said, I thought that the court would be very interested. I thought we can always reconsider a bar application. And I said, but if the court was to entertain such a petition, I wanted the law school to join the petition, and I wanted the Washington State Bar to join the petition as well as other organizations that might be, bar organizations that might be interested. And that's what happened. The petition was made by the law school, joined by the Washington State Bar, and we set a hearing on the petition to admit Mr. Yamashita to the bar of the state of Washington posthumously. The hearing was supposed to be held at the Temple of Justice, our wonderful home, which is not too far from where I'm sitting right now in the legislative building. But the great earthquake of 2001 intervened, and our building was closed to the public. Fortunately, my good friend, federal judge Bob Bryan, called me and said, Gerry, do you understand your building's closed? Do you need a courthouse? And I said, boy, do we. And so we set the hearing for the federal courthouse in Tacoma, which in a way was appropriate because history showed that Mr. Yamashita had come to the United States through Tacoma. And so fate would have it, the hearing was held in that wonderful courthouse in downtown Tacoma, the old Union Station, which has been refurbished and made the federal courthouse. And we had a wonderful hearing. Attorney General Gregoire, she was then our Attorney General, she spoke with a lot of other speakers, president of the bar, representatives of the law school. Governor Locke was supposed to speak, but he was out, understandably, touring the state to check on earthquake damage, so he wasn't able to join us. But after the hearing, the court granted the petition. All 9 members of the court signed the order admitting Mr. Yamashita to the bar of the state of Washington posthumously, ordering that those proceedings would be published in the Washington reports where all of our cases are reported, so there would be notice to the public now and forevermore that he was admitted to the bar. One of the wonderful things about this, quite a number of Yamashita's relatives, some from the United States and many more from Japan, actually came to the hearing, and it was just a wonderful feeling about, as I say, this had to be posthumously because he was deceased. I wish we could have done this during his life, but we try to rectify things as best we can, and that's what we did that day. And I'm very proud of the law school, the University of Washington Law School, and the court for admitting Mr. Yamashita to the bar of the state of Washington and correcting the by the way, we were careful to say we weren't being critical of the Washington Supreme Court back in the day when they upheld the denial of his admission to the bar. The law has changed since then. At that time, non-citizens could not become a member of the bar, and he was not a citizen of the United States. There was some language in the opinion that I felt was rather unfortunate, but this was an earlier time, and we weren't being critical, and we were just judging anew the petition and felt that he should be admitted to the bar. So I thought a happy day for the court and the Yamashita family.
Yeah, as you mentioned, I want to talk about some more details. But as you mentioned, family members came from Tokyo. They came from as far as the state of Maine. They had to overcome some travel challenges posed by the Nisqually quake. That was the so-called Nisqually earthquake of 2001, whose epicenter was just north of Olympia, and it registered 6.8 in magnitude. I just want to go back a little bit, Justice Alexander, and ask the question of why did you in the court think that this kind of treatment of Mr. Yamashita was worthy of your, or why was the way Mr. Yamashita was treated worthy of your intervention?
Well, I think if you look at the history, as I said, he suffered like the biblical Job. I mean, he was denied admission to bar. He couldn't own property. He couldn't have a business license. He was interned during World War II. I mean, talk about great suffering by a person who intellectually was considered a top-notch student, law student, and so the story, grabbed our attention, and the fact that the law school, the University of Washington Law School, my alma mater. I'm very proud of it. Felt that this was an appropriate way to celebrate its 100th anniversary. A sentiment that I agreed with, and the court did. It just seemed like it was totally the appropriate thing to do.
Right.
By the
And
way, I didn't mention that kind of a postscript on this. I mentioned, and we talked about the fact that a number of the Mashita family from Japan and the United States were here. They later made a rather significant contribution to the University of Washington Law School, unbeknownst to us at the time of the hearing, but later they made a contribution. And I thought, what a wonderful postscript, even though their ancestor was badly treated in an earlier time. They were appreciative of the fact that the law school had gone to bat for him at this time.
right. And to remind folks, there was also a sentiment that had, well, more than sentiment, action that had swept the country in 1988 when President Reagan signed the law that gave reparations to Japanese Americans who had been incarcerated during World War II, and an apology. And that was after a congressionally appointed panel produced a very lengthy report on World War II incarceration, and found that it was the result, they concluded, of wartime hysteria, a lack of political leadership, and I forget that third element. But I just want to take you back, Justice Alexander, to the day of the quake. So you're all set up to have this ceremony and people flying in from all over. And the day before, you are giving a tour of the Temple of Justice to some folks from Mongolia, if I've got that right.
That's right.
And the chandeliers start moving and plaster starts falling. Tell us a little bit about how that went.
Well, that day I had been asked to do something I always liked to do. I'd been asked by, I think, someone in the legislative arena to give a tour of the Temple of Justice to some young persons from Mongolia who were musicians who were going to be entertaining the legislature on their native instruments. And I agreed to do this. And I took them into our wonderful courtroom. And I'll never forget, we were standing underneath the very large chandelier. I don't know how much it weighs, but it weighs many thousands of pounds. And by the way, this was being recorded on video at the time with sound and picture. And I'm welcoming them, and all of a sudden, bang, the earthquake starts. And hearkening back to my childhood, I was always told to get into a doorway. Nowadays, they tell you to get under a table or something, but at the time, it came back to me from my childhood memories that you should get into a doorway. So I whisked them over to the entrance to the courtroom, and we rode out the earthquake together, the Mongolian students, the person that was doing the video, and myself. And this ended up on CNN, by the way. The tape is around somewhere if somebody wants to look at it. And for some reason, I was just chattering away and said, we have these every so often. Don't worry. And these young men couldn't speak English, so they had no idea what I was talking about. But we rode out the earthquake, and afterward, through the translator who was there, I asked them if they had ever experienced anything like this. And they said, "Oh no, never had before." But they were quite calm, and I think the only concern they had, their native instruments were in the legislative building, and they weren't allowed to go into the building to get their instruments. And I believe a state trooper did secure their instruments.
And didn't you give them a memento of this?
Yes, I guess the plaster was falling from the wonderful ceiling, and so I autographed pieces of plaster to take back to their country about the great experience. I'm sure these young men, it's been a long time, but they're probably still talking to people in Mongolia about the great earthquake in Olympia, Washington.
I'm sorry to laugh. And then, so then you have to scramble to find a new courtroom, as you said, and you were able to do that in part through the help of a vehicle that I did not know about. Can you tell us about that?
Well, yes, the Temple of Justice was closed, so Command Central became what we like to say in jest, sort of, was the Chief Justice Mobile. The Chief Justice does have a vehicle assigned to him or to her, and at that time it was a Ford Crown Victoria, big car, and it did have a phone in it, not a modern phone like today, but that became a kind of Command Central. And I remember I was in the car with Justice Charles Z. Smith, who was a senior member of the court, and Justice Charles Johnson and myself, the three of us. We got to find a courtroom, and that's when I talked to Judge Robert Bryan, who's a judge of the United States District Court for the Western District, Washington, a former state judge, by the way, and a good friend of mine. I've known him since I was 18 years old at the University of Washington, and he offered the federal courthouse to us for our ceremony. And as I said, in a way, that was maybe a more appropriate place to have it, because Mr. Yamashita had entered the United States through the port of Tacoma that many years ago, and so we were, and that building was not damaged at all in the earthquake.
And as you said, Justice Alexander, the Supreme Court was following the laws of the land at the time, and I suppose the state attorney general who argued for the state and against Mr. Yamashita was as well. But it just seems sad reading about it, because Mr. Yamashita really idealized America, and he argued his own case before the Supreme Court. He submitted a 28-page brief, and you know, his brief talked about how he expected a little bit more from the great country of the United States. And the Attorney General kind of mocked at one point Mr. Yamashita's arguments as worn out, star-spangled orations, which I thought struck me as sad, but I suppose that's an attorney doing their job at the time. Just as a kind of a postscript or footnote, we talked about Mr. Yamashita being incarcerated, and we also talked about the reparations for Japanese Americans. The United States Supreme Court, in its kind of last ruling on whether that incarceration was legal, because it had denied due process to people, the United States Supreme Court, in a decision known as Korematsu, basically upheld the ability for the federal government to do that under the military necessity reason. And isn't that decision still regarded as kind of one of the worst in the United States Supreme Court history?
I think many people think it's kind of an embarrassing blemish on the otherwise hallowed record of the United States Supreme Court over the years. Just trying to look at it as a amateur historian, I think we do things in wartime as a society sometimes that we wouldn't do otherwise. The internment was actually ordered by President Roosevelt, who is a hero for many civil libertarians, I think, in other respects, as a military necessity. And I've forgotten the number of his executive order, but it's
9066, I want to say.
Something like that, yeah. And I think history has shown that was not necessary, although I think the president felt in good conscience that that was the recommendation of his military and civil advisors. The Supreme Court, over the dissent of several on the court, upheld that. I think it's sort of an embarrassing decision when you look at it from today's vantage point, but nonetheless, as you mentioned in the Korematsu case, the what the president did was upheld. And there was a lot of, I'm old enough to remember World War II as a kid, a little kid, and there was a lot of paranoia about uh, uh, danger to this country. I know in Olympia as a little boy, we used to talk about if the Japanese bomb Olympia, were they going to bomb the Capitol building or the West Side Bridge or what? We know from history today the Japanese never had any intention of bombing Olympia,
Fading, yeah.
Washington. But at the time in 1940, late 41 or 42, 43, people didn't know. And they did things that may seem ridiculous today, but at the time seemed reasonable. So it happened, and all we can do is try to make amends. And I think that was appropriate when President Reagan signed the apology letter, and we paid reparations to the Japanese Americans who were interned who were still alive and who were interned during that period.
Mm-hmm. You made a great point about how wartime can change things or warp things, and another example of that perhaps is another case that you're proud of, and that is the one involving Chief Leshai, a leader of the Nisqually tribe, back when Washington was still a territory. And what happened to Leshai?
Well, Leshai, he's often referred to as Chief Leshai. He certainly was a leader of the Nisqually tribe, and also had a connection with the Yakima tribe, I think through his mother. He was a prominent Indian who was dissatisfied with I think understandably so, with the treaties that Governor Stevens had made with the various tribes in the area. And he was involved in the so-called Indian wars of that period. And he was charged with killing a member of the territorial militia by the name of Colonel A.B. Moses, I believe his name was.
Right.
And he was tried twice. The first trial ended in a hung jury, and the judge declared a mistrial. He was tried again, and this time he was convicted and was ordered to be executed. And he was executed for the killing of Colonel Moses. This conviction and the subsequent carrying out of the execution has really stuck in the craw of the Indian tribes, particularly the Nisqually tribe and tribes in the area over the years, and felt that a great injustice had been done. And and we were approached as a court to see if the record could be rectified, because his conviction was upheld by our predecessor court, the Supreme Court of the Territory of Washington, not the Supreme Court of the State of Washington, because this all occurred during the period that we were the federal territory of Washington. And we were approached to see if we could, and there were even overtures from the legislature urging us to do something about this stain on the judicial record of Washington. So that's what led to our involvement.
And just by the way of a little more context, this in particular, the territorial governor Stevens had struck this treaty known as the Medicine Creek Treaty, and Indians agreed to give up millions of acres of land in Western Washington for some small reservations, fishing rights, and a relatively paltry sum of money that actually the government was going to determine what it would be spent on. There is an X next to Leshai's name on the treaty, and there are many who believe that it was forged. And by the way, Leshai was, I think it's accurate when you say, Justice Alexander, that he was regarded as a a peaceful man who called the white people he associated with Bostons. And so there was at the time, we'll talk about some of the more complicating facts here. But at the time, for instance, of his ordered execution, the soldiers at the fort in Silicon, right, refused to have him hung there at the fort. And why don't you tell us why that is, and what are the key facts there?
Well, the United States Army, the regular army, was not at all sympathetic with the conviction and execution of Leschi, and they refused to allow the hanging to be carried out on military property, and it was carried out outside of the limits of Fort Steilacoom, and that the U.S. Army's opinion on this kind of was the issue in the trial, at least the first trial, because the first trial was held in Pierce County, and a defense was asserted that this killing, even if he did kill A.B. Moses, which is kind of questionable, but let's assume
one eyewitness.
There was a conflict in the testimony about that. But assuming he did, that he should not be tried for it, because this was a killing in the course of war, and the law of war is that soldiers are not prosecuted civilly for killing somebody in wartime. That defense was raised in the first trial, and I think that's what led to the hung jury. I think the jury couldn't decide that question, and but at the second trial, after a mistrial was declared in the first trial, was held in Thurston County, which was at that time less friendly to Native Americans than was the Pierce County area. And for some reason, that defense was not asserted in the second trial. And the only issue was, did he or did he not kill A.B. Moses? And they concluded he did. And that decision was upheld by the Territorial Supreme Court in an opinion which, if you read it today, you can tell in the first 2 or 3 sentences that he's going to lose the appeal. It's a very, in my judgment, a very unfortunate opinion of the Territorial Supreme Court. By the way, Territorial Supreme Court judges were not elected like judges are today in the state of Washington. They were appointed by the President of the United States and served at the pleasure of the President. And I think the 3 territorial justices at that time were not very friendly toward Native Americans, as subsequent Territorial Supreme Court justices were. But anyway, that defense wasn't asserted in the second trial, and he was convicted. And as I said, that opinion has stuck in the craw of our Native Americans, and a lot of other people over the years.
Right. So not just the Nisqually tribe, but others also see an injustice here.
And and I should mention, there's a lot of layers to this. Also, his brother, and I may not pronounce his name right, I think it was Quiamuth, was killed in the governor's residence here in Olympia in a killing that's never really been explained. He was being held there and died. So there was a whole lot of things going on that one causes them to scratch their head and say, what's going on here in the territory, particularly in the Olympia area, which we think of today as a rather liberal area politically, but at that time it was not, at least insofar as their view toward Native Americans.
There are so many layers. I mean, for instance, supposedly Leschai's executioner even said he thought he was innocent. But what made this so challenging? So the tribe, some tribal leaders get in their mind that they really want to correct this injustice. But this is challenging. This is a little harder than a posthumous
Yeah.
admission to the bar for Mr. Yamashita. So, what did they want, and what made that complicated for you to remedy?
I was approached by the tribe. Their chief executive at that time was Cynthia Ayal. She was strongly supported by John Ladenburg, who was former prosecuting attorney of Pierce County and then county executive, and urged the court to see if we could set the record straight on this and reconsider that decision, uh, uh, even though obviously Leschi was long gone, uh, and uh, also at the same time, the legislature had passed, I think, a resolution urging the court to do something about this. This is quite a bit different, though, than reconsidering a petition for admission to the bar, which the court is not foreclosed from reconsidering a denial of an admission to the bar. But here, this case had been decided many years ago by a court that was not the Supreme Court of Washington, but the territorial Supreme Court. And the question was, did anyone have standing to bring this issue? Leschi was obviously deceased, and I indicated that certainly anyone can petition the court to do anything, but I had to be honest with him. I just thought the court would probably not take this up as a regular matter because there was no standing. It wasn't. We weren't the same court that had issued the ruling back then, and I said I didn't think they could do that. But as time went on, we talked about, well, perhaps we could set up a historical inquiry court that could look into this as a matter of history rather than as a matter of technical law. And ultimately, that's what occurred. We set up, I think, with the agreement of the Nisqually representatives, to have a historical inquiry before a court consisting of 7 members, all of whom were judges, who would consider this matter as a matter of history and try to determine whether he was properly convicted. And that's what we did, and set the hearing for, not in Olympia at the Temple of Justice, but at the State Historical Society building in downtown Tacoma, Washington.
Even the idea of a historical court of inquiry was challenging for some of the tribal leaders to accept. Cecilia Carpenter, tribal historian and a mentor to Cynthia Ayal, was really worried that this would just lead to Leschi being convicted again, and then it would just be awful. They felt.
I
So
remember her. She was an elderly woman, kind of a historian of the tribe, really lovely lady, and she made no bones about it, that this was only agreeable to her if we guaranteed that this historical inquiry court would conclude that he was wrongly tried and executed. And I said, we can't do that. We have to, if we're going to have this, we have to hear it straight up and call it the way we see it. And I think that ultimately that was recognized, that had to be. And so we went into this with no preconditions that, yes, we would just sit up there and indicate that he was wrongly tried and executed. We would hear this matter, even though we weren't acting officially as the Supreme Court of Washington, but we would hear it with no preconceived notions.
right, you were determined that there not be a predetermined outcome, that it be kind of a real hearing by these. You and Justice Susan Owens recruited 5 other judges. It was kind of a diverse panel. And
It was a good. I felt really good about it. By the way, Justice Susan Owens, I wanted her to work with me on this because she was the only member of the court who she'd actually been a tribal court judge.
Right.
And she's not Native American, but she had that background. She was a tribal attorney up in the Olympic Peninsula, and before she came to the Supreme Court, and we together sort of handpicked 5 judges who we handpicked them on the basis that they were good judge, open-minded persons, and I felt really good about the court that we had. It was mixed racially and gender-wise, and so I thought it was a good court.
And then you had, and then one way that you were able to allay some of the tribal concerns is that there were many historians who were allowed to testify, and they really fleshed out this picture. And then
and by the way, Bob, interrupt. I should say that we really set this up as a contested matter. The prosecuting attorney's office of Pierce County agreed to act as the prosecuting attorney on this, and the Nisqually attorneys agreed to act for vindication of Leschi. So we really set it up as a
true adversarial
proceeding, and I felt good about that, and I felt very proud of the prosecuting attorney's office agreeing to do this, which may not have been politically popular, but they agreed to do it. So this will be a fair hearing.
Yes, I'm sorry I hadn't mentioned that yet. Top-notch prosecutors from Pierce County made the case, and
one of the 2 attorneys is now currently the prosecuting attorney of Pierce County.
Right, and
who, by the way, was a former law clerk of mine. I know she's a really good lawyer.
Wow. And I can't remember if you said it or somebody else said it, but they just knew that those professionals were not going to throw the case, if you will. So it was going to really, truly be an adversarial process. So hours of testimony, and then the judges recess to make their decision. But before they do, I just want to mention John Ladenburg gave the closing argument, and Justice Owens told me that she thought it was the best closing she had ever heard. And really briefly, if you don't mind, what John Ladenburg did, he kind of took this rhetorical flight where he told of a lone eagle that had circled over Leschai's original home after the chief's death, screaming this piercing cry before it would disappear into the tall trees. And Ladenburg then said, "Today, another solitary eagle circles that sacred land, and it too has a lonely cry. This cry demands to know when we will have the courage to stand up as one people in Washington and admit the wrong of the past. The eagle now cries for simple justice. Let your verdict free the spirit of the eagle," he concluded, "so it may rest in peace." So when the judges come out, tell us what you decided.
Well, before I do that, I should say, I think our central focus in this hearing, as the evidence came in, was this defense of war, because years later, it's really hard with a very skimpy trial court record to determine, did Leschai actually shoot A.B. Moses out there at Connell's Prairie in Pierce County many years ago? We were more interested in, was there a war here between representatives of the United States government, the territorial militia of the territory of Washington, and the Indian tribes? And if so, does the defense of war apply as it had been argued in the first trial? And I thought the most compelling witnesses were 2 Judge Advocate General officers from the United States Army, who testified as to what the law of war was then and what it is now. Really, it's the same, that you do not try soldiers for killing somebody in a war. And we concluded that this really was a war between an armed agency of the United States government and the Indian tribes who were dissatisfied with the treaties that had been made, including the Medicine Creek treaty, and that even if he did kill Colonel Moses of the territorial militia, he should not have been tried because it occurred during
Right.
the war. And that really was our decision, and unanimously, we made it rather briefly, kind of a postscript on this. We've been told by the executive director of the Washington State Historical Society that they had a wedding scheduled for the building. That the hearing lasted longer than we thought, which is often the case. And we had to get out of that building, so we got right to the point. And I said he should not have been tried, and because this occurred during a war, and the law of war is that you don't try soldiers for killing somebody in wartime. So we concluded he should be exonerated, and that was our decision. We made it rather quickly after we heard the evidence. I do want to say that John Ladenburg's closing argument was terrific. He's a really good trial lawyer, and I thought what he said that day was very moving, and I give him all the credit in the world for carrying the torch for. He's not Native American, at least as far as I know. I have no Native American blood, but he really carried the torch for the tribes that day.
Yeah, and the theater, if you will, was it's more than 200 seats were filled. It was jam packed, and when you read the decision, the people erupted in such glee and applause that you couldn't even hear you finish.
And many of them were wearing native costumes.
Right.
I shouldn't call them costumes, native dress.
Regalia, yeah, I think.
Regalia, yeah. And it was a very moving moment in the lives of all 7 of us on the court, I'm sure.
Yeah, and the Nisquallies, responded by saying things like, "Oh, our heritage is no longer as murderers," and things like that. So it was very, very meaningful to them. In the
and this was covered. Maybe you were going to ask me about this nationally. There's a story in the New York Times.
Right.
Stories all over the country. There was a book that's been written.
I was just going to mention that.
Okay, sure.
Yeah, I mean, the New York Times did cover it. They also covered the Yamashita case of yours, and then a Pulitzer Prize-winning author, Richard Kluger, has written a whole book about the Leschi incident called "Bitter Waters of Medicine Creek." So if anybody really wants to go deep on this, I recommend that. I also need to say, which I should have at the outset, that we have Legacy Washington has done a profile of Justice Alexander that we're just about to publish, and along with airing this episode of Lunch and Learn. And so you can learn more about Justice Alexander, his work, his life in that coming profile, and which will be available on the Legacy Washington website soon, if you'd like to know more. In the interest of time, Justice Alexander, I'm going to jump ahead to another bit of history involving you, and that is 2006, which would be your last campaign, and you knew it would be your last campaign for Chief Justice. And what made it historic is that there had been a rising tide of campaign spending in judicial elections around the country, but in Washington as well, and kind of an explosion. And it was mainly from some special interest groups that were driving these campaign expenditures up, and they came to favor a vehicle known as independent expenditures, which allows a group it was not donating to a candidate directly, because there are limits, or you will tell us about limits on those contributions, but it allowed that unlimited spending by an outside group in a race. They could not affiliate with the candidate, but and that helped them in the sense that they could air quite nasty ads, and it wouldn't come back and reflect poorly on the candidate, they were supporting, because they could always say that can't have nothing to do with that. That's us. So in 2006, Justice Alexander, at the peak of his career, I would argue, and widely respected and regarded as a congenial centrist, comes under attack from the Building Industry Association of Washington, who is going to spend just under $1 million trying to unseat you. And why was that, Justice Alexander?
Well, I've never really known exactly why the Building Industry Association of Washington decided to come after me. They have a perfect right to do that. It's a free country, and they have the right to spend their money in any way they want, even though it was unpleasant for me at the time. But I really don't know why they came after me, but they did, and I was on the ballot, and it sort of caught me a little bit by surprise. 6 years before, I'd run unopposed, and I don't know if I was kind of counting on that happening again. I guess I was hoping that it might occur, but it didn't. I would point out, though, as you've mentioned in your remarks already, that there did seem to be a trend developing in the early part of the 2000s that groups around the country were starting to eye judicial races as a possible way of gaining influence over decisions of courts. We have 50 states, and in most states, judges are elected in some fashion. In some states, they run on a partisan, as a Democrat or a Republican, some nonpartisan, like Washington, and some have other means of selecting judges by election, but not in a competitive way like we have in Washington. And so this kind of hit Washington a little bit in 2004. There was quite a bit of money put into a race between Justice Jim, two people who later did serve on the court, Jim Johnson and Mary Fairhurst, and that there was quite a bit of money in that election. And but in 2006, pardon me, the money really rolled into the election against me, and I have to say I wasn't totally prepared for it, and was not able to compete with the kind of fundraising that would have been necessary to equal what came in against me in that election. So it was a memorable experience in my life, but looking back on it, I think a good experience too. You gain from things that are oftentimes that are not always that pleasant at the time.
Right. There was some quickly. I guess there could be the possibility that the building industry wasn't so much opposed to you as they had a candidate they really wanted to push, a property rights attorney, and it ended up where it was just you and John Groan, this attorney, in the race. And there were no big contested congressional primaries that year. So in the primary election, you know, the Alexander Groan race was really kind of where the action was.
Yeah.
And in talking to some pundits, there's a view that the building industry thought that if they could take you out, that would really make them look powerful, and that might have been their motive. And they also had their eye on taking out Justice Owens as well, but she was in I guess what we would call a contested primary, so that wasn't going to be decided in September. They ran a number of ads that we won't go into in detail, but they distorted the truth, and in fact, my profile of you begins with you going to the cinema in Olympia one night to get away from kind of all these attacks. And before the movie, what comes up but an ad for your opponent on the big screen?
Yeah. Well, yeah, that did catch my attention. I am a movie buff. I like to go to the movies, and that kind of ruined that particular movie day experience. But I had really never seen that before in just a regular cinema, an ad for a judicial election. But again, they had a perfect right to do that, but it caught my attention along with a lot of other things, and I was just not able to compete with the kind of money that came out against me. By the way, I think you've touched on this. The law has since changed, but if only two people were in a judicial election at that time, the election would be decided in the primary. Today, the law has been changed, and if there's only two people, the election goes over to the determination goes over to the general election. I think actually that was a good change, even though I was pleased to be able to prevail in the primary. And there wasn't much on the ballot in the state of Washington at that time, so there was a lot of interest in this race for this Supreme Court and the effort to knock over the Chief Justice of the Washington Supreme Court.
Yeah, there would be 1.4 million in these independent expenditures or special interest spending just in your race, 2.7 million in all over 3 races that year. And what do you think was the the impact of you beating back that kind of well-funded assault?
Well, I did beat it back. I was able to prevail. Wouldn't say easily, but I did win fairly convincingly in the primary. And I think it did sort of inhibit, I may be wrong on this, but I think it sort of did inhibit organizations that might be thinking about trying to take out a judge who would not be able to raise very much money on his own. It inhibited them from doing that. And since that time, there hasn't been that kind of money going into judicial campaigns for the Supreme Court. And so I think in that sense, it probably had I would say, a good effect. Again, I always reiterate the fact it is a free country and people have the right to spend their money in any way they want. And I don't think judges can complain if they're challenged, but it's very difficult to compete with that kind of money. We couldn't do any television. They were using television ads. We didn't have the money in our campaign chest to do that, and so we ran sort of an amateur campaign, but we managed to prevail.
Yeah, and interesting times. It seems like the media really was able to grasp this idea that perhaps maybe our Supreme Court justices shouldn't be elected by the biggest donors. And so there were numerous newspaper stories and the editorial endorsements, I think all went your way and not
that helped a lot.
Yeah, not so much because of Mr. Groen, your opponent, but rather because it was seen as this barrage of spending by the building industry. It was just seen as not the kind of thing we want to determine who Supreme Court justices are. I need to note, Justice Alexander, that you early in this campaign, the legislature responded to this explosive spending in judicial races by creating new limits for direct contributions to judicial candidates. The law wouldn't take effect for several months after it was passed, and you decided to disarm yourself, so to speak. Tell us about that.
Well, the legislature set campaign contribution limits for judges. Prior to that time, we had campaign contribution limits in partisan races, but not judicial races. The legislature in March of that year passed campaign contribution limits, but they wouldn't go into effect until July, I think. And I felt like the legislature had spoken on this, and I indicated that even though they hadn't gone into effect, that I would abide by them. My opponent didn't, and raised a lot of money during that period from March to July. I felt, I guess one could say, I was sort of unilaterally disarming myself, but I didn't think anybody would contribute the kinds of money that to a judicial race that would exceed the campaign contribution limits. That had never happened really in the past, and so I didn't feel like I was doing much disarming, but I really was, as it turned out. And but I feel good about the fact that my campaign abided by what the legislature had determined, even though it had not gone into effect.
Right. And just in case anybody's wondering about a little bit more context and thinking maybe we're missing some of the story, I mean, some of the ads that ran against you had not even to do with your decisions. I mean, one of them just criticized you for being a judge a long time. And when pushed on that, the building industry leader, responded that, well, oh, we just are trying to say he's out of touch with voters, which I think the Tacoma News Tribune editorial said, yeah, and the Easter Bunny is real, something like that. And then another tried to criticize you for comments you made as Chief Justice and spokesperson for the court when Justice Bobby Bridge had a drunk driving incident. It just, it didn't seem like it really had to do anything with your record. They took a comment that you made, they took it out of context, and it made it seem like you were coddling a drunk driver, which wasn't the case at all. But I just wanted to add that in the, I wish we had a lot more time, because there's that 2006, excuse me, was so eventful. That was also the year of what I believe you have said was your most controversial decision, and that was in upholding the Defense of Marriage Act, which would not allow same-sex couples to be legally married. I'm wondering if in a minute or two, that was a 5-4 decision. I know this because I counted it, but I think there were 7 or was it 8 different opinions written by the 9 justices in that decision in all. And you, besides joining the 5-4 majority and upholding the law, you wrote a concurring opinion also saying, well, why don't you tell us what it said?
Yeah. Justice Barbara Madsen wrote the majority opinion, which I joined along with 3 others. So that constituted the 5-judge majority. But I did write a short concurring opinion, just simply indicating it. And Barbara Madsen had really done this as well in the opinion, but I felt like it should be emphasized that there was nothing we said in this opinion that would prevent the legislature, the representatives of the people, or the people themselves acting through the initiative or referendum to change the law, to broaden it, to allow marriage between people of the same gender. And I just wanted to make that point clear, that we were simply ruling on whether Washington's then extant law, which limited marriage to a man and a woman, whether it was constitutional. We felt at the time it was not unconstitutional, that there wasn't precedent supporting that argument, but that it was really up to the people or the legislature or the people if they wanted to change the law, which they subsequently did. Both happened. The legislature changed the law. It went to the people on a referendum, and they approved what the legislature had done. So that did occur, and I think as a consequence, marriage between people of the same gender was much better accepted when the law was changed by the legislature and the people than if it had been imposed on them by 5 members of the court. But be that as may, it was a very emotional matter before the court, and we took a long time reaching a decision. As you say, 7 judges wrote an opinion, but we finally did decide it. We decided it before the filing period for office took place. I felt very strongly that the court needed to do that. I didn't want the public to think that we were just sitting on this until the election was over. But I thought the people needed to know how we decided this before the election, and we did get it out.
Right, and by getting out before the filing deadline, there was gossip and rumor that the gay community would finance a candidate or find a candidate, recruit a candidate to run against you in that race. They did not. And in fact, the interesting thing about that election is that your support came from all over the political spectrum, from Republicans, Democrats, business people, environmentalists, all over the spectrum. I'm going to see if we can get through one quick aspect of this. So you make this decision, and it's really considered, one of the most important and kind of contentious decisions of that time. And the next day, you're scheduled to have an endorsement interview at the Stranger newspaper in Seattle. And for people who don't know, the Stranger newspaper is a kind of a brash and profane paper that is really important to a segment of Seattle's population, and its mission was, if that's the right word, shaped in good part by its outspokenly gay editor Dan Savage. So you could have dodged this interview the next day, but you go up to be interviewed by the Stranger. And first thing that happens when they sequester you in this room is Dan Savage comes in and he plunks down a framed picture of his adopted son right in front of you for you to look at through the entire interview, while then they start firing questions at you. And the Stranger recorded this and actually proudly posted some of that audio, which you can still find. And yeah, the questions are just coming fast and hard. And so why did you, as one of your law clerks, Kathy Georgia, told me, she didn't think like that many judicial candidates would go up and face that kind of fire. Why did you do that?
Well, I just felt as Chief Justice, I should never turn down a request for interview. I mean, there's, if the American Nazi Party or something wanted to interview me, I wouldn't go there. But there's very few groups that I wouldn't appear before. And I just felt as this is a newspaper in Seattle, they have a right to take a position on the election. And I knew when I went in there, I'd be about as popular as the plague, when going in there. And it was a difficult day for me. I haven't looked at the video of that interview. I don't know how well I did, but I did feel very uncomfortable, I must say, during the interview. But I answered his questions as best I could, and survived that day. As it turned out, my opponent in the election, John Groen, who, by the way, was a qualified attorney. He used to argue cases in front of us. He was a good lawyer, and on a personal level, I liked him as an individual. But he was deemed, I think, more conservative on the issue than I was, and so I knew that, but but at the same time, I knew that I would not be beloved by the Stranger when I went up there. But I toughed it out, and I think as the interview went on, it became less hostile. Right at the beginning with that picture was a difficult one for me.
Well, and just one other twist to this is that in the majority decision, the Supreme Court used, and correct me if I've got this wrong, Justice Alexander, but they used the reasonable basis standard. Was the state law, was there a reasonable basis to believe that it was legal? And at this time, judges like yourself are being criticized by special interests for being quote unquote activist judges because they make a decision that tends to be unpopular to certain groups. And in this case, the majority and yourself could not have been kind of less activist. You deferred to the legislature, which, the criticism of activist judges is that they do not. So interesting little.
The standard of review on constitutional questions, if you're being asked to determine was a law passed by the legislature, is it unconstitutional? There's a principle that you have to grant the legislature a great deal of deference. In order to overturn a law passed by the legislature, we have to be convinced beyond a reasonable doubt that the law is unconstitutional, and that's very deferential to the legislative branch. And I subscribe to that. I think not every issue that comes up is of constitutional magnitude, and historically the laws relating to marriage have been under the aegis of the legislature, determining age at which people can be married and other issues relating to marriage. And so we went into this with that in mind, that we had to be somewhat deferential to the legislature, and we just weren't convinced beyond a reasonable doubt that the deference that we have for the legislature should be overcome in this particular.
Right.
And I'm not being critical of the four who were in dissent. I think Justice Fairhurst wrote a very good opinion. She's a good judge. I have a lot of respect for her. She later became Chief Justice, and we just happened to see the issue in a different way. And that's what happens in courts.
Right, and in a postscript, we should note that the stranger did indeed endorse you, and they did it with some profanity.
Sort of a left-handed way, yes, they did.
And then there's one more postscript where you later ran into Dan Savage, I believe at KCTS or something like that.
Yeah, we were on a panel. This was much later, and the issue then was whether, if the matter of broadening the definition of marriage was on the ballot, would I vote for broadening it? And at the time, I think my answer was, well, I'd have to think about it, but I'm inclined to think that I would vote yes as a citizen, not as a judge, but just as a citizen, if that issue was before me, to broaden the definition of marriage. And he came up and shook my hand and said he appreciated the fact that I said that. So I have no enmity toward him, and he was very friendly on this particular occasion. I hope he feels the same way.
So, Justice Alexander, probably because of my long-windedness, we're nearing the end of time, and I'm so sorry because we didn't talk about your biography in full, and the fact that you were born in Aberdeen and you moved to Olympia when you were 6, I believe, and you had what seemed to you kind of a magical childhood at the time. And then you went on to Olympia High, where you were the student body president. You thought at one time maybe you were going to get kicked out because you were caught in a very, very, very low stakes football betting pool. And when
10 cents a square, I think it was. But
then when you went to see the formidable principal, Willard J. Matters, he gave you an hour of detention. But anyway, there's so much more we didn't talk about. I'm sorry, your parents. I would just tell people that you can read this in the profile that will soon be published by Legacy Washington about Justice Alexander's rich history, if you will, and indeed he really did in the 1993 New York City Marathon beat Lynn Swan. Justice Alexander, the records can be looked up. This is so cool about the New York City Marathon. The records can be looked up, and your time can be looked up, and where you finished, roughly in the middle of 26,000 plus runners, and then. Just quickly tell us the story about running into Lynn Swan, who was a famous USC Trojan and then a Pittsburgh Steeler.
Pittsburgh Steeler,
yeah,
one of the great NFL receivers of all time, and a very nice man. He was in the race carrying a backpack of I'm sure today they could probably put all that stuff into a watch or something.
Right.
But at the time,
He was broadcasting
but
for
he was
ABC.
broadcasting the race, and as we got about a couple hundred yards from the finish line in Central Park, he was a little bit ahead of me. So I put on a burst of speed as much as I could at that time, and I passed him. And of course, nobody in New York cared about Gerry Alexander crossing the finish line, but I could hear a little bit later, "Here comes Lynn Swan," but he finished behind me a little bit. It just, as it turned out, we were staying at the same hotel. I saw him the next morning on the elevator and introduced myself. And I said to him, "I beat you in the race yesterday." And he asked me my time. I told him, and he said, "Yes, you did." And I said, "If you think I'm not going to tell everybody in the Northwest I beat the famous Lynn Swan in the New York Marathon, you got another thing." I mean, he laughed about that. He was very, very nice about it. And I'm sure if this had been a 100-meter race, he would have beaten me by 50 yards. He was really fast. Or if even in that race, if he didn't have this backpack on, he would have finished much ahead. But that was a big remembrance for me in that really wonderful race. What a way to see the great city of America. There's a 26-mile marathon that hits all 7 boroughs of New York, and or 5 boroughs, or 5. I said 7, 5 boroughs. Pardon me. Even the
It felt like 7.
but that was a great day and a great experience for me.
Well, so again, I'm sorry to the audience, but there is a lot more about Justice Alexander's life and work in this profile. And I would be remiss because Justice Alexander and I are both film buffs. So I would be remiss if we didn't conclude with asking Justice Alexander about his favorite films about law and courtroom drama.
Well, I think my favorite is a movie that the great Paul Newman made toward the end of his career. It wasn't exactly at the end, but it was close to it, called The Verdict. I taught professional responsibility at the University of Puget Sound Law School for 4 years. And there were some great ethical issues in that case that are in that movie, which are explored. And I used that movie a bit in my class. I also like Anatomy of a Murder, which was a great James Stewart film. George C. Scott played in it, one of the attorneys in that movie. It's a great movie with a musical score, by the way, by the great Duke Ellington, who was actually in a cameo in that movie. But that's a great movie. Also has some good ethical issues in it, which I use with my class. I've always liked movies about military court-martials. Breaker Morant, which is an Australian movie which focuses on a court-martial during the Boer War. It's kind of a little bit of an anti-British, which is not uncommon in Australian movies. But I like that movie a lot. A Few Good Men is a great one with Tom Cruise and the great Jack Nicholson. I never miss a movie with Jack Nicholson in it. A lot of memorable scenes there. And another great one I think it was directed by Stanley Kubrick. Paths of Glory, which is starred Kirk Douglas. Adolphe Menjou was in this movie. It's about the First World War and an incident in the French army with an entirely American cast, which I think today they'd probably get people with French accents, but this was an American cast. But it is a great movie and has a great court-martial scene involving Kirk Douglas, who I think was really never got the great. I don't think he ever won an Academy Award, but he was a great actor. He really was. I think a better actor than his son, although I think his son. Paths of Glory, a Kubrick film. It's a kind of an anti-war film, but it's a great movie about some great action scenes, but also some great court-martial scenes in the First World War. So those are what 4 or 5 that I read.
Yeah.
There's a lot more, but those are
great. Yeah, and so for the audience, maybe this is a pitch. I think Justice Alexander and I could do a pretty good Siskel and Ebert kind of movie show. So
You asked me
thanks.
one time what was my favorite movie, and you put in the book The Wizard of Oz, which is one of my favorites. But I also want to add, I think that another great one, and again, this is Jack Nicholson, One Flew Over the Cuckoo's Nest, which I think is one of the great movies of all time, which was filmed in our neighboring, at least in part, in our neighboring state of Oregon.
Right, written by the great Oregonian Ken Kesey.
That's right.
The book was, yeah.
Yeah.
Okay, well, we could. I was just gonna, when you mentioned Kirk Douglas, I was like, oh, I just saw Out of the Past, that great 1947 film noir where he plays the heavy, and Robert Mitchum is pretty much the good guy. Anyway, so
Yeah.
thank you, Justice Alexander. I'm sorry we didn't cover all that, but again, it will be available very soon for folks to read. And I thank you again for your time. Again, Justice.
Maybe sometime we can just do one on the movies, one of these lunch things.
I will. I am there for that, Justice Alexander.
Yeah.
So thank you again. Again, the longest serving Chief Justice in the history of Washington Supreme Court, Gerry Alexander, whose career was, I believe, in good part influenced by growing up in Olympia and the virtues of small town Olympia. And we didn't even talk about the 1953 state championship football team that you were on that went up to Seattle on Thanksgiving Day in front of a crowd of 13,000, beat Queen Anne High 7-6. But that's also in the book. All right. I mean, the profile. Thank you all so much. Thank you, Justice Alexander. We could do this again and for a long time. Appreciate it very much.
Thank you. This was fun. The time went by really quickly. So I enjoyed the interview a lot.
Wonderful. Take care. Thank you
Okay.
all.